Welcome everyone to the Federal Bar Association Ketam sections, the rounds, FCA news with Tejinder Singh. The rounds is Tejinder's regular analysis of noteworthy FCA decisions. I'm Scott Oswald, programming chair of the Ketam section with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, on June 16th, the U.S. Supreme Court published its long-awaited decision in Polanksy versus Executive Health Resources. The opinion was penned by Justice Kagan. What do you think?
Yeah, so in this case, the question before the court was what rights the government has to dismiss a quitem action over the relator's objection. The government had argued that it has basically unfettered discretion to dismiss these cases whenever it wants, and it doesn't have to intervene when it does so. Polanksy principally argued that no, if the government initially declines to intervene, it forfeits its power to come in and dismiss the case belatedly. And he argued in the alternative that even if the government has that power, it's circumscribed by a sort of arbitrary and capricious standard. The Supreme Court rejects both of those arguments. Instead, it affirms the Third Circuit's judgment almost in toto on the basis of its reasoning. And it says, actually, the standard is the government does have to intervene. If it's intervening belatedly, it has to show good cause, although the court never explains what constitutes good cause or wouldn't constitute good cause. And then it says, once the government has intervened, just ordinary rules of civil procedure apply. And that specifically references Rule 41 of the Rules of Civil Procedure, or Rule 41A, which governs voluntary dismissals. And that imposes slightly different standards on the government depending on the stage of litigation. But the court says that in all but the most exceptional cases, if the government wants to dismiss, it can come in belatedly and it can dismiss. And so essentially, the government wins, not on the sweeping atextual crazy logic that it was pressing in the lower courts, but on a more textually grounded version of that argument.
So almost as you predicted in our previous editions of the rounds, Tejinder, the court pretty much took the Third Circuit's standard here and applied it right across the board.
Yeah, that's correct. And look, I always thought it was very obvious reading the statute that the government has to intervene before seeking to dismiss. In general, it would be really, really weird for someone who's a non-party to a case to just show up and start filing dismissal motions. That would be very strange if you or I tried to do it in any other case. And so the idea that there was just this special weird rule that didn't require even that minimum step seemed quite obviously wrong, but that still left open a lot about what the substantive standards were going to be. And because the False Claims Act doesn't really say. And I think that the court arrived at an answer that it kind of makes sense.
So at this point, in terms of kind of the state of things from both the relator's side and the defendant's side, let's take the defendant first. How does this change kind of how they approach their requests to the government to have the government kind of both not intervene or potentially dismiss a case under C2A?
I think that this decision largely preserves the status quo. The status quo before, there was, of course, this spaghetti mess of different legal standards that applied in different circuits, but they were really more kind of semantic differences than substantive ones. What the court says is basically if the government wants to dismiss, it's going to have the ability to do that as long as its reasons aren't crazy. And you should account for the relator's interests when you're figuring this out in the hearing that the statute requires, but they don't count for that much because these lawsuits are principally about the government's interests. And I think that was more or less the state of play before, that the government felt like it could dismiss cases that it wanted to dismiss. The defendants felt very comfortable asking the government to dismiss cases, perhaps too comfortable. I think we've heard complaints from some folks in the Department of Justice that some defendants will request again and again and again to dismiss a case throughout the course of discovery. I think that the decision probably won't change very much of that. But I think one thing that it may do, to the extent it does anything, is it suggests that if the government wants to come in later, it should have some justification for the delay. Although the court doesn't flesh out what the good cause for belated intervention standard is, it does say that part of Congress's reasoning in allowing the government to dismiss belatedly is to account for new information. And so there's a flavor, at least in the opinion, that asking the government to dismiss over and over, based perhaps on facts that it already knew at the outset, is a fruitless exercise, and that the government will tend to think that it is. So I think hopefully what will happen is there'll be some tamping down of that practice. I think the government would like that. And I think that the focus will be on what's changed since the case came out from under seal, when the government is deciding whether to come in belatedly.
Let's turn to the dissent, Tejinder. Justice Thomas pens a dissent in the case, and there are a few surprises, including Justice Thomas musing about the possibility of the False Claims Act qui tam provisions being unconstitutional. Tell us about this.
Yeah, so to start with the statutory question, Justice Thomas actually accepts the relator's argument. He pens a solo dissent where he says, I think the relator is right about the reading of the statute. And this is something that I thought might happen when I looked at the relator's argument. I said, look, if you're just being a literal textualist, this is a pretty decent argument for how you would read the statute, because there's that provision that says if the government intervenes belatedly, it cannot compromise the rights or the status, limit the rights or status of the relator as it does so. And so you would think that the right to continue the action is a core right. Maybe the majority says no, but Justice Thomas bites on this. He says, yep, that's it. And so if the government doesn't dismiss the case at the outset, its hands are tied. The relator is right. The government should not have been able to dismiss. And then Justice Thomas does something a little different. He says that now, in light of that, you have to consider whether it's constitutional to have qui tam actions at all. And Justice Thomas does not purport to answer that question, but he says that in his mind, there are serious questions under the Appointments Clause of the Constitution, whether somebody who is not an officer of the United States can represent the interests of the United States in litigation. And so he opens the door to asking questions about this. I will say this is something that Justice Thomas frequently has done in the past. The most famous example that comes to mind is there was a double jeopardy case decided in 2019 called Gamble versus United States, which was about whether this thing called the dual sovereignty doctrine violated the double jeopardy clause. And the dual sovereignty doctrine was the idea that if the state and the federal government prosecute somebody for essentially the same crime, is there a double jeopardy problem if the defendant wins in one of those prosecutions? Does that preclude the other? And Justice Thomas had written for a long time saying, hey, I think dual sovereignty might be a problem. And then when the court finally gets its hands on the merits question, he wrote a concurring opinion saying the dual sovereignty doctrine is fine. And he said, oh, my earlier skepticism was unjustified. So he has a habit of throwing these questions out there without necessarily knowing the answer and just kind of inviting courts to think about it. And I think that's what he's doing here. And I think that he will invite courts to think about it. You saw also in this case, Justices Kavanaugh and Barrett issued a one-paragraph concurrence. And the one-paragraph concurrence says, we agree with the majority's reading of the statute, but we also agree with Justice Thomas that somebody should think about the constitutionality questions here. And so there are 3 justices of the Supreme Court who have now said, let's think about this. They haven't presumed to provide an answer or even a framework for figuring one out yet, but they have said maybe there's a question here. And so I do expect one of the consequences of this case is going to be renewed litigation in the district courts about the constitutionality of private lawsuits.
So at this point, Tejinder, it looks like you got 3 votes to look at this issue. That's one short of granting cert. Should the qui tam bar be concerned?
Yeah, is the short answer. I mean, look, the other way to read the opinion, of course, is to say that there are 6 justices who think there's nothing to this. Right? The majority does not say, oh yeah, there's constitutional questions here. And anyone who wanted to join the Kavanaugh concurrence was free to do so. He got 1 taker on it. So there aren't enough votes for cert. let alone a decision on the merits. The problem is that there are a couple of circumstances in which the Supreme Court will grant certiorari. The most common one that we talk about most frequently is the existence of a circuit split. But a second example is if a lower court, a court of appeals, deems a federal statute to be unconstitutional, the Supreme Court will essentially always take that issue up. And that's because a circuit deeming a statute unconstitutional essentially creates an immediate circuit split, because in that circuit, that provision of federal law no longer functions, and in all the other circuits, it's still functioning. And so both for the reason of preserving uniformity and for preserving comity between co-equal branches of government, if the courts are going to deem a federal statute unconstitutional, the Supreme Court always takes it up. And so the way I read the opinions is that they're kind of like an invitation for district courts and, more importantly, courts of appeals to take a look at this question. And if a court of appeals decides to take the plunge, they will say, okay, this is unconstitutional. The Supreme Court will then definitely take it up, because even though there were only 3 votes here that want to get into it, no, there will definitely be at least 4 votes to not shirk their responsibilities. And so they will take it up, and then they'll have to resolve the issue on the merits. Now, I still think that the composition of the votes suggests what the outcome on the merits will be. I think the court is highly likely to find the statute is constitutional, but that was also true before this opinion came out, and it's less likely than it was a few days ago. So yeah, I think if I were the qui tam bar, and if I were the government, I would be concerned about this, because declined lawsuits benefit the government as well. They allow the government to take advantage of the resources of the private bar to help redress fraud on the public fisc. And so the partnership that currently exists between relators bar, and the government, I think that the court has definitely put a shot across the bow. For someone like me who litigates almost exclusively declined cases, you know, this is an extinction level event for my practice if it happens. And so I'm certainly worried.
Tejinder, thank you. And thank each of you for joining us for this edition of the Federal Bar Association qui tam sections, the rounds, FCA news with Tejinder Singh. We'll see you in July.